My lord, may I be permitted to mention item number 60, my lord, for upgradation, because this is a very urgent matter. I am going to be punished, my lord.
I am going to be punished.
Punished, yes.
Yes,
Well,
how?
departmental proceedings started by an authority who has no power and jurisdiction.
All right.
Is that 60, my lord? I have given notice also.
No, right now I am not upgrading. Yes.
My lord, may I kindly mention 3 analogous hearing matters, my lord,
Will not be updated.
No.
for extension of interim order. Interim order is expiring on 31st March, my lord.
Give the number.
My lord, may I be permitted to mention one matter? My lord, the petitioner has challenged the disciplinary proceedings as well as the suspension order. He is
What
suspended.
do you want?
My lord, this matter was fixed by Honorable Justice Shogata Bhattacharya on 10th of March, but it is not appearing in the list. I have mentioned it previously, but it is still not in the list. My lord,
Maybe the file has not come. You have to wait.
my lord, maybe my lord,
No.
my lord, he is suspended
This
since.
for inclusion, my lord. My lord, kindly, my lord. This person is about to retire. He has not received his salary for the past 2.5 years. And the small point is that the authority that has passed the order has no, my lord, right to pass that order. That point is only required to be adjudicated. Very small
Yes.
point, my lord.
Yes.
Kindly, my lord. Kindly, my
No.
lord.
Yes.
My lord, may I permit mention one matter, my lord, on last occasion, one matter was disposed of, my lord, where the petitioner name, my lord, erroneously placed Gautam Bishwas. Instead of Gautam Bishwas, A and O, my lord.
For correction.
My lord, can I give this? For
No,
inclusion? My lord,
please.
My lord kindly considers he is under suspension since 30th of September 2024. My lord, he is
On
not
the
receiving
list.
his pay.
Item number 1. Item number 1, I'm led by Mr. Ronajit Roy. I'm paying for not today, Lord.
Not today?
Not today.
All right, not today.
I am appearing on behalf of state respondents.
You took time on the last occasion or somebody else took time?
No, I am not taking.
You
I am
done.
not freeing. Yeah.
That means the Transport Corporation took time. All right, not today.
I'm deeply obliged.
Item 4.
Old lady, I appear for the petition. Yes. Everyone was waiting outside.
See whether they're still there or they have just.
They will be coming, milady. May I start? Yes. So on the last occasions, I have submitted that what is the error before the inquiry officer. Four dates are important over here. One is 18th of November 2020, the date on which the Honorable Supreme Court has stayed the warrant of arrest. Keeping that in my mind, I have continuously I have not passed the warrant of arrest. Rather, I have secured other things like securing the proclamation and attachment. Everything was there. Thereafter, on 5th of July 2021, when the Honorable Supreme Court had dismissed the SLP, which means there was no stay of the arrest, which was placed before me on 24th of August 2021 in a later stage. Now, the same fact was not known to me that the Honorable Supreme Court has dismissed the SLP, for which I could not take cognizance about the dismissal of the SLP. When I was made aware about the fact of dismissal of the SLP, I have immediately issued the warrant of arrest. The sole allegation against me that on 5th of July 2021, the Honorable Supreme Court has dismissed the SLP. So you were supposed to issue the warrant of arrest after that date only. Rather, you have not done so. Now, on the last occasion, a query was made before me that how the inquiry officer has dealt with the fact of. To deepest of respect, milady, he has not.
Does not.
No.
Did
That
you bring this to the
yes,
notice of the
yes.
inquiry
I will go
officer?
through those pages. Yes. Firstly, Milady, kindly come to page 74. There comes the questions of perversity. I have specifically taken that point. Page 74 and extent P9. This is an application for requisitioning the trial court record, which is in contemplation of the Rule 11, Sub-Rule 8 of the Rules of 2007, which was I have handed over to a ladyship. It says that the inquiry officer shall, on receipt of the notice for discovery of production of documents, forward the same copies thereof to the authority in whose custody or possession the documents are kept with requisition for production of the documents by such date as may be specified in such requisition. So I have Rule 8, Sub-Rule 8. So I have made a requisition before the Honorable Inquiry Officer requesting him to bring all the records from the trial court so that he can go through each and every orders which I have passed. How the Inquiry Officer has dealt with. Page 74. It was actually rejected, page 77, the order portion. Today, the charged officer, presenting officer, and the complainant, namely so-and-so, is present. Page 77.
Yes.
Today is fixed for further cross-examination of PW1, Miss so-and-so. The charged officer has filed an application praying for production of case record of so-and-so, which is the case I was dealing with. The charged officer submits that before further cross-examination of PW1, the complainant, the record of the above-mentioned case is required. The charged officer further submits that without production of the said case record, it is not possible for him to further cross-examine the witness and prayed for adjournment till production of the said case record. The charged officer further alleges the application that on so-and-so, I had allowed the complainant to talk over phone during so-and-so. These are skip over to the next page. Page 78, which says, on the very first day of the proceeding, that is proceeding number 1, dated so-and-so, the charge officer had inspected the documents relied by the presenting officer, and during inspection, the charge officer did not raise any objection and has not asked for further document, and he has not satisfied with the documents after inspection from the case record of the instant proceeding. Thereafter, the penultimate paragraph of that page, the charge officer has prayed for production of the case record of so-and-so. After perusing the application and after hearing the charge officer, I am of the view that the proceeding is initiated on the basis of complaint of one so-and-so, and after receipt of the complaint of complainant, preliminary inquiry was conducted. I have raised a point that during the course of preliminary inquiry, I was supposed to give an opportunity of hearing, which was not provided to me in terms of rules of 2007. Thereafter, and during preliminary inquiry, the relevant documents have been obtained, which have been made as a part of the memorandum of charge as list of documents, which was duly supplied to the charged officer. In this proceeding, I am not deciding the criminal trial pending before the learned court. I have decided only with regard to the allegation level against so-and-so. In view of the above, I am of the view that the application filed by the charged officer for production of lower court records of special case number so-and-so is misconceived and accordingly is rejected. My specific case was that you place the entire record so that you can have the knowledge that how I have dealt with the fact of dismissal of the SLP of the Honorable Supreme Court.
But then where is the specific submission that
I will go through that. Yes, there comes page 80. Thereafter, the charge sheet was served upon me. Thereafter, the disciplinary proceeding was initiated. Page 80. Point number 5. On 5th of July 2021, the Honorable Supreme Court had vacated the interim order dated 18th of November 2020. Copy of the order dated 5th of July passed by the so-and-so is marked as Exhibit F. 6. I had issued summons to the accused Rajat Sinha Roy only after submissions of the charge sheet, which was in accordance with law. Point number 17. Page 82. Yes, page 82, point number 17.
Yes.
Copy of the order passed by the Honorable Supreme Court dated so and so was received by me on 24th of August 2021, which was recorded by me video order number 35 dated 24th of August 2021 in special case number so and so. So I have placed this case that I have received the order of the Supreme Court only on 24th of August 2021.
And how did you get it more than 1.5 months back?
Yes, some of the learned advocates related this same fact to the deepest of my respect. Criminal revisional application was filed with respect to my orders, challenging my orders. The Honorable High Court in a other coordinate bench has also dealt with the fact. The Honorable coordinate bench has also not aware about the fact of dismissal. The same, to the deepest of respect, the same error has already been occurred by the Honorable High Court only, by some other Honorable Judge of this High Court. Thereafter, page 87 is very important. These are all part of the inquiry proceedings.
Yes.
Page 87, question number 9. It appears from the complaint of so-and-so, the preliminary inquiry report of the learned register, vigilance, and the orders passed of special case number so-and-so, that you being judicial officer in the rank of so-and-so, showing judicial impropriety, passed irrelevant judicial orders, again vague charges, in the case record of Alipur case number so-and-so, video order dated so-and-so, contrary to the judicial norms and discipline, sacrificing judicial standard and misuse of judicial power. What do you want to say about this? My answer: it is false allegation. I have passed all the above mentioned orders in conformity with the Honorable Supreme Court order dated 18th of November 2020, the Honorable Calcutta High Court order dated so and so, and the Honorable Supreme Court order dated so and so, received on 24th of August 2021. All the above mentioned order has been passed prior to the receipt of the Honorable Supreme Court order dated 5th of July 2021, which was received by my court only on 24th of August 2021. Therefore, prior to 24th of August 2021, Mr. Rajat Sinha Roy was enjoying the interim protection granted by this Honorable Supreme Court, and all the orders have been passed by me by considering the special law applicable to the accused under which the charge sheet so and so was issued. Last line: none of the orders passed by me are contradictory, and none of the orders have been set aside by any court of law. These orders do not constitute any misconduct. I have passed this order in my routine judicial functions without favoring any of the parties. Most specifically, the order for which I was victimized, rather, if I may say so, rather the misconduct has been alleged against me. None of the order was tested before any higher forum. 11th of August 2021 and 18th of August 2021. These are the two orders which I have passed and allegedly for which I have been misconduct. I have allegations of misconduct. Those two orders never challenged before any higher authority, nor before the Honorable High Court, nor before the Honorable Supreme Court. If the complainant was so aggrieved by the orders of 11th of August and 18th of August, he could have challenged those orders before any higher authority. Thereafter, the inquiry officer has passed the inquiry report, had issued the inquiry report. Lady, kindly come to page 123.
123.
Yes. Your starting portion, page 124. This has been reiterated. Page 17, which I have already placed before your ladyships. Now, page 127 is
This 123, 124 is a part.
reiteration of the part of the disciplinary proceeding. Cross-examination has been done. The bottom of the page, cross-examination of DW charged officer is concluded. Inquiry officer signature, the presenting officer signature, and the charged officer signatures are there. Page 127.
Correct.
This is in conformity, page 127 is in conformity with the rules of 11 sub-rule 12 of rules of 2007. Lady kindly takes up the rules of 2007 once. Rule 11, sub-rule 12.
Yes.
When the case of the disciplinary authority is closed, prosecution case, the judicial officer shall be required to state his defense orally or in writing as he may prefer. If the defense is made orally, it shall be recorded and the judicial officer shall be required to sign the record. In either of the cases, a copy of the statement of defense shall be given to the presenting officer in if any. So these are the proceeding after the prosecution case is closed. I have made a request, page 127, which is the post-evidence statement of defense under Rule 1112 of the rules of 2007. Page 127 of the rules of writ petition. After conclusion of the prosecution case, which is of the disciplinary authority of this honorable court, I have placed specifically that date, page 127, starting portion, page 128, Roman 2 first, order dated 24th of August 2021, reflecting the receipt of the Honorable Supreme Court order dated 5th of July 2021 by the special court, which is me. So I have placed this document. Thereafter, Roman 4, order dated 18th of September 2021, reflecting the direction of execution of warrant of arrest against Rajat Shira Roy. So I have done that. The mere fact is that the order of the dismissal of the Honorable Supreme Court was never placed before me, before issuance of the orders of 11th of August or 18th of August. For the first time, I came to learn about the dismissal only on 24th of August. Thereafter, on 18th of September, I have issued the warrant of arrest, which was the sole allegation against me. And these are all part of the inquiry proceedings. To the deepest of respect, the honorable inquiry officer was supposed to deal with the fact of all these things, but he has not. There comes the questions of perversity. Thereafter, page 137 of the writ petition.
Yes.
Now, Milady kindly takes up the rules of 2007 once. Page 137 is in conformity with the rules of 2007, Rule 11, Sub-Rule 15. It says the inquiry officer may, after completion of the production of evidence, so I have done so, production of evidence, which I have just now shown. Here the presenting officer, if any, and the judicial officer, or permit them to file written arguments in support of their respective cases if they so desire. So I was supposed to give an opportunity to file my written statement of arguments. This is the page 137 is the written statement of arguments. Serial number 14 is important. After receipt of the Supreme Court order on 24th of August 2021, IO was directed to execute warrant of arrest against Rajat Sinha Roy at once vide order dated so and so dated 8th of September 2021, Annexed 4 of my written statement of defense, which I have just now shown. But the said order has not been considered by the DA, which is the disciplinary authority, though specifically mentioned by PW2 in his preliminary report. This proves that the charges framed by DA are arbitrary and biased without considering relevant orders passed against the Rajat Sinha Roy. So these are all part of the inquiry proceedings. Repeatedly, I am mentioning that I am receiving the order of the dismissal only on 24th of August. Thereafter, immediately thereafter, on 18th of September, the next judicial day, I have issued the warrant of arrest. It is not a case that I have never placed those documents before the Honorable Inquiry Officer. Yes.
Assuming 24th of August you get to know
Yes,
and you issue the order on the 8th of September,
yes.
what happened in the interregnum?
From 24th of August, 8th of September is near about 14 days.
2
So
weeks.
generally, yes, 2 weeks. Generally, the lower court actually places the next date only on 2 weeks. So I have to peruse those record of the Honorable Supreme Court. I have to go through the records of the Honorable Supreme Court. I have to go through the order of the Honorable Supreme Court. Thereafter, a petition was also filed, page 139.
Yes.
After considering this petition, I have issued the warrant of arrest. So it is not the allegation against me that you have issued the warrant of arrest after 2 weeks of the having knowledge about the fact of dismissal. The allegation is that I have not done so.
Not done so in proper time.
Yes.
This is important.
In the meantime, I have issued some other orders, which I could not have done so. Thereafter, rules 11, sub-rule 19.
Yes.
Which says that the disciplinary authority on receipt of the report from the inquiring officer shall forward a copy of such report to the judicial officer, intimating the punishment proposed for making representation within 30 days from the date of receipt on the finding of the said report, provided that in case of disciplinary authority does not agree with the findings of the inquiring officer, it may record separately the reasons, and those reasons shall be communicated to the judicial officer along with the report of the inquiring officer or otherwise for filing representation within 30 days from the date of show cause notice. This has not done with me.
What has not been done?
The proposed punishment, which was supposed to be given me an opportunity that these are the proposed punishment against you by the disciplinary authority, has never been communicated. Complete violations of rule 11 and sub rule 19. Straight away they have imposed punishments against me.
Yes.
Similarly, for the last and submissions, page 90, the inquiry report is very important. After the inquiry report, the Honorable Disciplinary Authority was supposed to indicate me the proposed punishment, which has not been never communicated to me. Then page 90.
Page
90, the report of the Honorable Inquiry Officer.
yes.
Para 2, on completion of para 1, once so had submitted a written report on.
Prior to that, page 89, I can see a communication by the RG.
No, this is
Giving you
the
30 days time to file your explanation on copy of the report,
yes, this is the report,
not the proposed punishment.
not the proposed punishment. I will go through
All right.
page 90.
Yes.
One so had submitted a written report on so to the so. On receipt of the said complaint, the Register Vigilance has submitted the same before the Honorable Chief Justice acting, and his Lordship has directed for preliminary inquiry. On completion of preliminary inquiry, the Register Vigilance has submitted his report along with all documents to the Honorable Chief Justice on so. The Honorable Chief Justice, so pausing for here for a moment, the on completion of the preliminary inquiry, I have already submitted that in terms of Rule 11 2B, I was supposed to give an opportunity of hearing during the stage of preliminary inquiry, which I have never been given. There comes the second line. The Honorable Chief Justice has placed the said preliminary inquiry report before the Administrative Committee, consisting of the Honorable Chief Justice and other 6 senior judges. The Administrative Committee, in its meeting held on so decided to initiate departmental proceeding against Sri so and also taken decision to place so under suspension. The committee has also appointed the so as inquiry officer and so as the presenting officer. Here I have already submitted that the power of the Administrative Committee to initiate a departmental proceeding, the AC committee has no power to initiate any departmental proceedings. Only the full court has the power to initiate the departmental proceeding. I have already submitted that the committee has appointed the Honorable Justice so as inquiry officer on the date when I was given the charge sheet. So the prejudged mind was already there, in violation of the rules of 11.4. Which specifically says that when the judicial officer submits a written statement of his defense and the disciplinary authority having regard to the articles of charge and the written statement of defense thereto. So charge sheet was given me on the same date the inquiry officer is being appointed. Thereafter, from para 3, the charge sheet has been quoted. Page 97, para 5.
Yes.
The review application filed by so was placed in the Administrative Committee meeting held on so and the committee has rejected the review application.
Where are you?
Page 97, bottom portion, para 5.
All right. Yes.
The review application filed by so was placed in the Administrative Committee meeting held on so and the committee has rejected the review application. I again reiterate that the Administrative Committee does not have the power to reject my review application in terms of Rule 17 of the Rules of 2007. Rule 17 says that a judicial officer who is suspended or is deemed to have been suspended under any or the provisions of these rules may apply for review of suspension of the order to the disciplinary authority who has suspended him, and thereupon the reviewing authority, notwithstanding anything contained in these rules, may call for the records of any of the cases and review any order and confirm, modify or set aside the order. So the disciplinary authority who has the power to issue for charge sheet or who has the power to suspend me has not dealt with the fact of review application. Rather, the Administrative Committee has rejected my review application.
You read out Rule 17.
Rule 17, review of rules of 2007,
Yes.
which says a judicial officer who is suspended or deemed to have been suspended under any or the provisions of these rules may apply for review of suspension order to the disciplinary authority who has suspended him, and thereupon the reviewing authority, notwithstanding anything contained in these rules, may call for the records in this case and review any order and confirm, modify.
Did you give the entire rules?
Yes, rules 17.
Rule 17 did you give? I can
Yes.
see 12, 13. Rule 17 of Rule 11 or what?
Rules 2007. The entire rules is of judicial service classification, control and appeal rules. Yes. Rule 16 is of appeal.
No, it's only till 12 you've given. 13.
Really, I'm handing over my rules.
Yes, joint inquiry is here. Then this page possibly has not been given. ওখানে খুলে যায়নি তো?
So
Yes.
So review says a judicial officer who is suspended or is deemed to have been suspended under any of the provisions of these rules may apply for review of suspension order to the disciplinary authority, which is the full court, who has suspended him, and thereupon the reviewing authority, which is again the full court, notwithstanding anything contained in these rules, may call for the records of any case and review any order and confirm, modify or set aside the order.
But then how do you know it's only the administrative committee who took a decision and not the full court?
That is apparent over here from the reports of the inquiry officer. Para 5, the review application filed by the charged officer was placed in the administrative committee, which is again wrong, held on so and so, and the committee has rejected the review application. And in para 2, I have already placed that the administrative committee consisting of the Honorable Chief Justice and other 6 senior judges, which does not include the all the honorable judges of this honorable court. Thereafter, immediately straight away, I was suspended. The inquiry proceeding was initiated. Lastly, page 142.
The initiation has to be done by the full court. Where is it mentioned?
Yes.
And is it only relying upon this that you getting to know that the full court was not intimated?
Yes. That is apparent over here. The inquiry report was only communicated to me.
All right, you show me.
Yes. Page 63.
No, the rules.
Yes.
Where is
Rules 11.4.
11.4.
I'm sorry, Rule 11.2. The disciplinary authority shall draw up or cause to be drawn up the substance of the imputations of misconduct or misbehavior into the definite and distinct articles of charge. So only the disciplinary authority has the power to draw up the charges.
Who is the disciplinary authority?
The Honorable
Yes.
Full Court of this Honorable Court.
Yes, where is the definition?
That is in the appellate side rules, milady.
Show me.
Rule 1 and Rule 3.
Show me.
Rule 1. May I read, milady? I do not have
Yes.
the copy of the appellate side rules.
I একটা tag দিন help.
There shall be an administrative committee of the judges composed of the Chief Justice and at least 4 other judges to be nominated from time to time by the Chief Justice, which is the definition of the administrative committee. Thereafter, Rule 3 says, the administrative committee shall have power without reference to the judges generally, A, to make recommendations for appointment to the selection grade post of the higher judicial service, B, to make recommendations, I, for selection of the assistant district judge for appointment to the so-and-so, for selection of the assistant district judges for appointment as assistant sessions judges, 3, for selection of munsins for appointment as assistant session judges. C is important, to make recommendations, A, for confirmation of assistant district judges and munsifs, B, for allowing the munsifs to cross efficiency bars, 3, for appointment to the selection grade post of the assistant district judges, D says to make recommendations for disciplinary action including degradation, suspension against members of the higher judicial service and state judicial service.
That is the administrative
Committee's power, yes, to make recommendations.
Yes.
Yes. And the decision or the power of the initiation of the disciplinary proceeding has been contemplated or in conformity with the Honorable Full Court only.
Where is that?
Yes, Rule 13 says, when the administrative committee has acted under Rule 3 of this chapter, which is recommendation of this one, so the relevant paper shall be laid down on the table and there shall be circulated to all the judges as soon as after each meeting as possible a notice in which shall be stated the matters which have been laid before the committee and the manner in which they have disposed of, with a note that in absence of so and so.
How do you get to know that it was not circulated to all the
Never
judges?
communicated to me. At least it is not apparent for me. Let them show, let the Honorable High Court show that they have
Is
placed
it
this
not
document.
disclosed in their
No.
affidavit
No,
that it was circulated to the
Never.
full court?
never.
High Court administration, are you taking note of the points?
It's all points, Milord. We have taken
Yes.
all points.
Really, these are more or
You have
less.
to show documents that these were circulated.
If that is so, Milord, subject to correction, I am indicating my mind prima facie that if your lordship was a part of the full court committee, obviously yes, then Milord, possibly the administrative decision, the same person cannot hear this matter. No high court judge is competent to hear this matter.
In that case, where will these matters go?
That means, Milord, it is the compliance of the rule. First of all, decision has to be taken by an administrative committee. Disciplinary action means issuance of a charge sheet. The rest part is a mere formality. The decision has to be taken. The approval, he must show that the consequence of such failure. Otherwise, what is the effect or ramification of such pseudo non-compliance?
Here it is all over. The major punishment
First-
has also been
Right.
imposed.
I say, Milord, that Rule 1 and Rule 3 conjoint reading. Rule 13 is an independent rule which he has interpreted. Rule 1 and 3 administrative committee is competent and empowered to take a disciplinary action. A disciplinary action against the employee of the High Court or the subordinate judiciary under Article 235, which your lordships will court exercises supervisory jurisdiction under the Constitution. Disciplinary action means issuance of a charge sheet. Issuance of a charge sheet is a conscious decision. Chief Justice, the master of the roster, along with the other uni judges, 4 or 6 consistent of the committee, 6 judges, they have taken a decision. The decision to communicate, it's a kind of a consultation. It does not await any approval. It is a mere communication. He has to show from the rule that such compliance is mandatory and the ramification is the entire procedure stand appreciated and the ultimate ramification or it leads to the inescapable conclusion that
So that he's showing, he's trying to show,
let it go. That the
Yes.
rules contemplate.
trying to show that only.
Yes. This has already been clarified by our High Court only in various decisions. I will place that one of the decision is Honorable High Court at Calcutta versus Mintu Monlik and another.
It is citation to board.
2019 SCC Online SC 2384. Para 15. দেখাবো Para 15. SC 2384. This is before the Honorable Supreme Court only.
Paragraph?
Para 15.
Yes.
It says, on so and so, a copy of the inquiry report was furnished to the magistrate who duly submitted his comments thereto. On so and so, the administrative committee of the High Court decided to impose punishment of compulsory retirement upon the magistrate, and on so and so, the decision of the administrative committee was ratified by the full court by circulation. I was never been communicated that the communication has been ratified or has been vetted by the Honorable Full Court. There is not even a single document they will even place that these documents or this decision has been vetted by the Honorable Full Court. The administration. বলবেন পরে পরে.
Possibly it was circulated.
Possibly. Even then, the decision of the Honorable Full Court was communicated to the Principal Secretary, Para 15. Judicial Department, on so and so for issuance of necessary orders, and on so and so the order of punishment was passed. On so and so, the respondent number 1 preferred an appeal under Rule 16 of the Rules of 2007. There is a provision for appeal. On receipt of the appeal, the Honorable Governor of the West Bengal forwarded the same memorandum of appeal filed by the respondent number 1 to the same High Court for its opinion. On so and so, the opinion of the High Court was forwarded to the Governor, who rejected the appeal, after which the magistrate approached the High Court on its judicial side under Article 226 of the Constitution of India. The Registered Vigilance and Protocol who conducted the preliminary inquiry, on the basis of which action was initiated against the magistrate, as also the inquiring authority embarked upon detailed examination of the scope and ambit of the powers of so and so, and the legality of the action of making an inquiry himself by entering into this so and so. The last line, the inquiring authority as also the registered vigilance misdirected themselves by exceeding the scope of their task of making factual inquiry, obvious of the established principle that an error of judgment in itself does not constitute misconduct. This is one of my submissions, that at best, if you can say that this was an error apparent. So an error of judgment does not constitute any misconduct, which was never challenged before any higher authority. Then para 19. It appears from the judgment of the single judge that the single judge was swayed by the fact of the appeal of the petitioner that has been rejected. The single judge completely overlooked the fact that there was in effect and substance no appeal, for an appeal from the decision of the High Court was rejected on the basis of the opinion of the same court. This is in contemplation of Rule 16. There, para 22. The learned single judge rightly observed that a court can interfere with an order of compulsory retirement when it fails to the test of reasonableness. The question is whether an order of compulsory retirement can be held to clear the test of reasonableness when all that is established in the inquiry is that magistrate had boarded the something cabin of the one solitary occasion so and so. The illegality of the action was discussed at length, but whether there was an dishonest or wrongful intent, culpability or malafide on the part of the magistrate was totally overlooked. Exactly my case. There was no finding against the magistrate of the malafides any motive or ill intent. Thereafter, para 24. Para 24. It is settled that an error of judgment does not per se constitute misconduct. If the railway magistrate had acted bona fide but exercised his powers erroneously based on the perception of the powers of a judicial railway magistrate, he could not have been held to have committed misconduct. The entire inquiry proceeding appears to have been conducted under the rules of 2007, which, to say the least, immediately needs to be amended. This was the observation of 2019. Till date, the rules has not been amended. Under Rule 11 of the said rules, no order of imposing any of the penalties specified in items 1 to 5 of the Rule 10, which includes compulsory retirement, is to be made except after an inquiry in the manner provided in the rules, for which the disciplinary authority is inter alia to draw up or cause to be drawn up the substance of the imputations of misconduct or misbehavior into the definite and distinct articles of charge. Rule 2C defines the disciplinary authority to mean the authority competent under the said rules to impose penalty on the judicial officer. The rules are completely silent as to which is the authority competent under the rules to impose penalty on a judicial officer. It is doubtful whether the Registrar General was at all competent authority to draw up the charges. Exactly my case. The Registrar General has only drawn up the charges. It is also not clear if the High Court has examined and approved memorandum of charges independently applying its mind. Be that as it may, Rule 16 and particularly Rule 16.3 is patently invalid for the reasons discussed in the judgment of the division bench under appeal. the High Court is requested to consider recommending amendment of rules of 2007 rules, particularly Rule 16, which is expressly invalid, in that an appeal made to the governor has to be referred to the High Court for his opinion. Same issues, same query. In other words, the High Court takes a decision and appeal therefore must be decided on the basis of the opinion of the same High Court, which is absurd. So this has already been contemplated by the Honorable then Justice Indira Banerjee in Supreme Court. On the last occasion, I have already placed the case of Honorable Justice Ananya Bandyopadhyay versus Registrar General of this court. I have handed over that judgment.
Yes.
Citation is 2015 SCC Online Cal 8340. Yes.
2340.
Paragraph 187. The 2007 rules, and in particular Rule 11(2)(bi) thereof, contemplates an opportunity of hearing to a judicial officer after preliminary inquiry before issuance of charge sheet, which has not done in my case. In this case, no such opportunity was given to the writ petitioner. Para 188, Rule 11(2)(a) requires the disciplinary authority to draw up or cause to be drawn up. Again, the disciplinary authority, which means the full court only. The substance of the subsistence of the imputations of misconduct or misbehavior into the definite and distinct articles of charge. Rule 11(2)(b) requires the disciplinary authority to draw up or cause to be drawn up a statement of imputations of misconduct, statement of imputations of misconduct or misbehavior in support of each article of charge is to contain a statement of relevant facts, including any admission or confession made by the judicial officer. The question of admission of confession by the judicial officer can only rise when an opportunity is given to the charged officer after preliminary investigation and or before decision is to taken initiate departmental proceedings, which has not done in my case also. Then para 189, furthermore, an inquiry might only be held if upon consideration of the written statement of charge sheeted officer, the disciplinary authority is of the opinion that the charge sheeted officer was prima facie liable for major punishment. No inquiry is necessary for imposing a minor penalty. In my case, the major penalty happens. As argued by Mr. Mukherjee, formulation of opinion upon consideration of reply of whether inquiry of imposing major penalty was at all necessary was a condition precedent for appointment of inquiry officer. Exactly my case.
180. Paragraph 180.
190. 193 thereafter. There can be no dispute that the rules of 2007 have the force of law. It is well settled that when the statute requires things to be done in a particular manner, is to be done in that manner at all. Exactly my case, the rules has not been followed. Thereafter, Milady kindly takes up para 201.
Paragraph
201. In this case, the writ petition was entertained and directions issued for affidavits. The High Court administration did not take the point of alternative remedy when the writ petition was moved before the Honorable Single Bench. On the other hand, the parties invited the earlier division bench to decide the writ petition along with the appeal, whereupon direction was issued for affidavits, and it is well settled that once a writ petition is entertained, direction issued for affidavits, and the writ petition is kept pending for some time, the writ petition should not be rejected on the technical ground for existence of an alternative remedy of appeal, which they have not taken that point. Furthermore, The court may decline to entertain a writ petition on the ground of an alternate.
Remedy is not the issue, so do not read 203.
Yes, then 203. The High Court means the Chief Justice and all his companion justices. In this case, the petitioner did not have an efficacious remedy of appeal since the disciplinary proceeding has been initiated and charge sheet issued pursuant to a decision of the Administrative Committee of Judges of this court, approved by the full court by circulation, which they have not shown. By the same resolution of the Administrative Committee, approved by full court by circulation, an inquiry officer was appointed. Rule 11.4 of the rules of 2007 appears to have been escaped the notice of the Administrative Committee. There could be no question of an appeal under section 16 of the appeal would, in view of the section 16.3, so and so, exactly alternative remedy. Thereafter, paragraph. Para 214, the last line. Furthermore, the disciplinary proceeding has not been commenced and conducted in accordance with the mandatory procedure prescribed under 2007 rules, which have the force of law, and in particular Rule 11.4b thereof. The written statement of charged officer, if filed within time stipulated, would, under the said rules, necessarily have to be considered by the High Court, that is the Chief Justice and his companion justices, before initiation of an inquiry. More so in view of the ambiguity of the rules of 2007 as to who would be the disciplinary authority. That has not been contemplated anywhere. Conjointly, rules of appellate side, Rule 1, 3 and 13, it will transpire, or it is apparent that the full court means all the honorable judges of this High Court. 216, the High Court being the control of the subordinate judiciary under Article 235 of the Constitution, the full court would have to take the decision of whether an inquiry should be at all conducted upon consideration of the reply of the charged officer. So at the stage of preliminary inquiry, if I was given an opportunity of hearing, I could have shown that, you see, that I came to learn about the dismissal of the Honorable Supreme Court only on 24th of August. The preliminary inquiry has been conducted without even giving me an opportunity of hearing. So this is the case of Learned Registrar General versus Anona Bandyopadhyay. Thereafter, this is a case of P.C. Joshi versus State of UP and others. Citation নেই, আমি দিয়ে দিচ্ছি গো। Yes, fine. Yes, fine. Yes, Indian. ইয়েও হয়েছে, রিপোর্টেডও হয়েছে, আমি রিপোর্টেড ভার্সন শুনলি।
You've given 2 copies over here. এটা ফেরত দিয়ে দিন।
একটা কপি আমাদের জন্য।
Are you relying on any particular paragraph?
Yes. Para 7 and 8 and 20.
20.
Yes, 20.
Para 7, 20 or
7, 8, 20.
Judges are also public servants. A judge should always remember that he is there to serve the public. A judge is judged not only by the quality of the judgments, but also by the quality and purity of his character. Impeccable integrity should be reflected both in public and personal life of a judge. Who stands the judgments over others should be incountable, and this is high standard which is expected of the judges. Thereafter, the 2012 8 of has been quoted over here. Para 20. We are,
Doesn't have para 20. P.C. Joshi?
yes, page 8 of the 10, page 8 of 10. The bottom portion, there is a
There is only 5
pagination.
pages.
12 of the yesterday.
I have only 5 pages. Paragraph 12, no costs.
Paragraph 12, no costs. The order says we have no hesitation.
বারো দিয়েছেন
হ্যাঁ
আচ্ছা, আচ্ছা, ঠিক আছে, দিচ্ছি। I was going through some other judgments which has been quoted over here only.
Right.
Para 7 says, in the present case, though elaborate inquiry has been conducted by the inquiry officer, there is hardly any material worth the name forthcoming except to scrutinize each one of the orders made by the appellant on the judicial side to arrive at a different conclusion. That there was possibility on the given set of facts to arrive at a different conclusion is to no ground of distinct indict judicial officer for taking one view, and that too for alleged misconduct for the reasons alone. The inquiry officer has not found any other material which would have reflect on his reputation or integrity or good faith or devotion of duty, or that he has been acquitted with any corrupt motive. My case is also same. There is no allegation that I was having the ill motive or corrupt motive at all. There was no allegation to that effect. At best, he may say that the view taken by the appellant is not proper or correct and not attribute any motive to him which is for extraneous consideration that he has acted in that manner. Exactly my case, no allegation. If in every case,
if he completes
How long will you take?
only 6 judgments are there.
6 more?
On the next,
It's already
Very well,
11:40.
on the next date, I will conclude about it.
Finish with this only.
Very well. If in every case where an order of an subordinate court is found to be faulty, a disciplinary action were to be initiated, the confidence of the subordinate judiciary would be shaken if the officer would be constant fear of writing judgment as to not face a disciplinary inquiry, and thus judicial officer cannot act independently or fearlessly. Indeed, the words of cautions are given in so-and-so case that merely because of the order is wrong or the action could have been different does not warrant initiation of the disciplinary proceeding against the judicial officer. Exactly my case. The allegation is that you have not looked into, you have not issued the warrant of arrest. That is at best a wrong order which was never challenged before any higher authority. In spite of such caution, it is unfortunate that the High Court has chosen to initiate departmental proceeding against the appellant in this case. There are other 2 charges in respect of which the appellant was found to be guilty. One so and so, these are the charges. Thereafter, para 9, the last charge is to effect that the appellant has appointed so and so. The action of the appellant was to to call of any action because of the appointment made by him was not pursuant to any improper motives or such as illegal gratification or otherwise. How the same appoints to misconduct is not clear to us at all, except to state that he was only in charge of district judge. Thus, we find that the findings recorded by the inquiry officer are totally vitiated for want of any legally acceptable or relevant evidence to support the charges of misconduct. In the absence of any evidence, the inquiry officer could not have reached to the conclusion in the manner he did, and these findings affirmed by the disciplinary authority also stand vitiated. The learned counsel for the respondent sought to rely upon the number of decisions so and so. This court to indicate the scope of interference in these matters of this nature. We have adverted to the board principle attracted to the case of this nature which is sufficient for disposal so and so. Thereby the appeal was allowed over here. So my case is that there was no allegation against me from any other gratification, any other monetary transaction, anything. So the misconduct does not itself stand in my case. This is at best a error apparent which was not placed before me. At best a wrong order which was again not tested before any of the higher authorities.
All right, please come.
এটা সাইটেশনটা একটু বড়
Learned advocate for the petitioner
এটাই করছি
continues with the argument.
আসলে করে 20 বাদ যাবে
Where April, next Thursday.
Very well.
Don't call any other matter.
My Lord, I'm appearing on behalf of the petitioner, my Lord.
Yes, please.
May it please your Lordship,
Yes.
the present writ petition concerns the non-payment of statutory interest on delayed retirement benefits. My Lord, the delayed period is 2 months, 21 days from the date of retirement.
How many days?
2 months and 21 days from
2
the
months and 21 days.
from the date of retirement.
All right. When did you retire?
My Lord, may I present the chart for your Lordship?
Yes.
The first name, my Lord,
Ashok Kumar Gupta.
Ashok Kumar Gupta.
Hmm.
Date of retirement is 30th September 2018.
And you got it in December.
December.
2 months, 21 days. And next one is 1 month, 17 days. How much interest will you get?
That is the question.
It's calculated at 10%.
That is the problem, my lord. Just a 2 months delay.
Why are you making this 2 months delay and you are forcing these people to come to court?
My lord, kindly consider, my lord, kindly appreciate this thing that they are actually retired from that day of the 30 September of 2018, and they received the payment, delay payment and the gratuity payment, everything, 21 of the, December. So 2 months delay.
Why this delay? This is
So-
the query of the court.
You know, this is the supposed to be
My lord, may I
take the
submit?
time to processing the thing. My lord, kindly appreciate this.
Does the processing take place after an employee retire? It doesn't. It takes place prior thereto. Then why will the authority delay in making payment?
and
Yes.
Lord, kindly and they that petition
Who is
never
this they?
mean that petition never approached the authority, just advocate concerned
The
that
petitioner is to approach each and every employee after he retires. He have to continue running after the employer to release payment. Is that the way? Then
worship, it's not the way.
you are doing your professional work. If your bill is not paid, you will go and charge your client. How many times will you go? You will not go. Why will an employee go? There is no reason. And then Article 12 authority. Why will the petitioner go and run after the employer for releasing the terminal dues? Would you like to submit anything?
One last point, my
Yes,
lord.
please.
The petitioner should
Hmm.
not be made to suffer for the administrative inactions, my lord.
Yes, sir. Please come, Pradeep. Delayed payment of terminal dues, usual order, 6% interest. The date of retirement, date of disbursement is here. Delay তো আমরা বলি না কতগুলো দিন delay তো- Yes,
Grateful, my lord.
yes, please.
This next matter is similar matter.
Similar matter. You've given that chart
Yes, my lord.
and
Second-
the dates are there.
Yes, my
All
lord.
right. You got enough time to prepare. I'm very happy with your performance.
Really grateful, my lord, for the opportunity.
Serial to I prefer the respondent.
Yes. Same order will be passed 6% interest.
Grateful, my lord.
Yes, next.
Bolo.
Yes.
My lord, in this matter, I am on behalf of the state respondents. My lord.
Only clear, my lord, under the 1962 Act, my lord, the authority concerned initiated a proceeding. I am praying for my lord, conclusion of that proceeding.
You are praying for
Conclusion of that proceeding. My lord, kindly come to
conclusion of
page
the
32.
proceeding.
Actually, they are to approach the tribunal, my lord.
The tribunal is non-functional.
Yes,
My lord, who is
So-
tribunal?
land tribunal, my lord.
My lord, this
Land
is-
tribunal?
No.
Huh?
My lord, under the 1962 Act, unauthorized
কি হয়েছে?
eviction of unauthorized occupant, I approached before, I made a complaint before the concerned SDO. My lord,
But how are you coming within the service jurisdiction? Oh,
no, no, my lord,
this is
this
assigned.
is my release, my lord.
Oh, this is
matter, my lord, the
assignment.
assignment for my lord. My lord, kindly comes to page 32.
32.
My lord, the SDO concern initiated a proceeding on the basis of my complaint, and my lord, the matter was taken up for hearing before the SDO concern on 16/12/2025, and BLRO concern was directed to submit a report whether my lord, the other side claim this is their royalty land, and government said this is the my lord, the vested to the state. So the report call from the concerned BL and LR.
Returns করেন 30 তারিখেরটা দেয়
But I am praying for my lord, the conclusion of that
ঠিক আছে,
proceeding.
This order was passed page 32 in the matter of Dr. Shubhajit Roy versus Shoilen Mondol.
Yes.
How are you connected, Srimati Najma Roy?
My lord, that is
Hospice.
my lord, the hospice is the my lord, the hospice India is the my lord, the charitable trust, my lord, and my lord, he is the secretary, and my lord, the kindly see my lord, page 32, page 32, my lord, the last paragraph. Dr. Subhajit Mondol, the complainant, submit that the disputed land is vested to the state, and a proposal for long-term settlement of the aforesaid vested land for building of the hospice care center is under consideration. My lord, Dr. Rai also, my lord, the in the hospice, being him as a secretary, my lord, he's the president, is the secretary, Najma Rai. Najma Rai filed this writ petition, and complaint was lodged.
Complaint under which provision of law?
My lord, 1962 Act, eviction of unauthorized occupant from the government land.
Eviction of unauthorized government from the government land was initiated.
1962 Act.
Initiated.
Initiated, my lord, the page 32 proceeding.
By the subdivisional magistrate.
My lord, that is the
Regarding
appropriate authority.
encroachment. Or regarding encroachment.
No, he is the appropriate authority. My lord, the page 33. My lord, the private part
Who's for
respondent.
the state?
I am from the state. We are from the state.
What is your submission?
Yes, my lord, this is the conclusion of that proceedings, my lord.
It has been concluded?
Yes.
When? Was notice given to the petitioner? Is
Yes,
the
yes,
petitioner aware of
yes.
such conclusion?
Yes, yes.
When?
I am not. Mala kindly see.
You are the private respondent.
Mala kindly see the document handed over by my learned friend.
It's the same order.
Same order. Mala that is mala report call.
No,
for
no, no.
Another date. Mala he is submitting
no.
this document.
No, what you have annexed, it was annexed on the date of 25th December proceedings, but not on 30th proceedings. We have gone through.
Face order no. Face order no.
Reach the officer within 30th of December 2025. That is a report. The clarification.
Yes. Last page. The first paragraph.
To the last page,
The block development officer Sunapi is directed to demolish or remove the unauthorized construction. So,
Purpose is solved.
one thing, my lord. Last order, my lord, kindly see 13th
December 25.
2025, my lord, without giving no opportunity of hearing my
Challenge it. You challenge it. The petitioner had came.
They have appeared and their advocate was present and it was recorded. Lordship HON'BLE has represented by his learned
All right, please come.
At the first page, my lord,
The instant writ petition was filed
Solo bar.
praying for a direction upon the subdivisional officer
Content is.
conclude the proceeding initiated for removal of the unauthorized documents. Stop paragraph. Learned advocate representing the state respondents has produced a copy of the order dated 30th December 2025 passed by the subdivisional officer Baruipur, South 24 Parganas, wherefrom it appears that the proceeding has been concluded. Acha, for eviction bollam na, under the West Bengal Public Land bracket open, eviction of unauthorized occupants bracket close Act 1962. এখানে already আছে তারপর কি বললাম concluded and the block development officer was directed to demolish / remove the unauthorized construction. Stop. Learned advocate for the petitioner and the learned advocate representing the private respondent submits that copy of the said order was never communicated to them. Stop. Let a copy of the order handed over in court today. Order dated.
We have
30th
already
December 20
already handed.
Acha, লেটটা কেটে দিন. Copy of the order dated 30th December 2025 has been handed over to the learned advocate representing the petitioner and the private respondent. নামটা লিখে নিন. HON'BLE. Spelling also check. What is the spelling of your client? Mondal spelling?
HON'BLE.
M-O or M-A?
MO is mentioned here. MO is mentioned in the order. MON.
M-O-N?
ONDA.
Because the petitioner has implemented M-A-N. I do not know. Then next time something will come.
Yes.
HON'BLE.
আমারটা কি লিখেছে MON লিখেছে
এখানে তো ও আছে in court today. Stop. The date of communication of the aforesaid order shall be today. That is 27th March 2026. Stop. It will be open for the parties to take further necessary steps in the matter in accordance with law. Stop. The writ petition stands disposed of.
One thing, my lord, demolition proceedings will be concluded on 2nd April 2026, my lord.
2nd
April 2026.
April.
Yes, my lord. Kindly see page number.
Is one of the concerned police station was directed.
Yes, direct to provide adequate police assistance on 2nd April 2000 Thursday to maintain law and order in this area. I kindly just received this order and beg to file my appeal, my lord.
Yes, of course.
Now this court will not go anything beyond. And see, the next portion is also there. Objection on behalf of the OP may be filed against this order before the undersigned within 25th March. You did not get this. And that is the reason I have recorded that today is the date of communication for all practical purposes. So obviously the SDO, you apply before the SDO, he'll take steps. 2nd April is still some time to go. I have given liberty to all the parties to take steps in the matter in accordance with law. Dismissed. Did you file your wakalatnama? Leave granted, wakalatnama.
Yes.
But item number 4, my lord, is pertaining to group 2, I think, my lord.
And not assigned and not part-heard, nothing of the sort. Why is it here?
My lord,
It is returnable, your lordship,
Maybe there are so many matters returnability. Ki determination. If it is not
pertaining to higher scale of
then-
higher scale.
earlier determination.
নেই তো আরে আমাদের ছিল তখন ডিটারমিনেশন released for want of determination.
Grateful. Plus, if petition and name. Grateful.
For the petitioner,
For the respondents, your lordship.
there was a direction to my lord, made party to one person, namely Tulsi Bauri. Lord, I have made him party, and copy has been served. The issue regarding
But then if nobody is present today on behalf of the added party, then I cannot take up the matter.
Today also, my lord, there is a resolution.
Not today?
Yes,
Only not today. Take back this service.
service has been affected.
Keep it with you. ফেরত দিয়ে দিন। Grateful, your lordship.
Yes, ma'am. I'm for the petition, ma'am.
Yes.
With leave of this honorable court, my lord, I am submitting a supplementary affidavit.
Lordship, may permit you to have the copy of the same.
The copy has given to.
No copy.
Yes. ওই জাহাজ করে ওইটা বলেছে
Yes.
the petitioner mother, my lord.
Is the somebody appeared on the last occasion?
Lordship, I appeared, the matter was dismissed. Subsequently,
You have been removed.
Lordship, he was removed long time back, but there was a communication gap, so I'm not coming up. So I was entrusted and I appeared, and that the matter. So
Yes.
The petitioner's mother, my lord, the Borki major, was an employee. Then my lord expired. But still now, my lord, the service benefit has not been given.
Service benefit.
And after the death of her mother, my lord, nothing has been paid, my lord. By the
When did the person expire?
expire, my lord, 8 May 2016.
From 16 to 26.
Yes, sir.
Read petition was filed in 24. Yes. What do you want? Financial benefit?
Yes, my lord. Service benefit, others, actually, the amount has lying.
You do not want employment.
No, my lord.
they sought for, but they didn't. Lordship, আপনার হয়ে গেছে? Lordship, in this regard, in this matter, your Lordship, maybe to permit to file a report. Why I say this? Because your Lordship, there has been a rivalry claim. In the nomination paper, the Berkey Majan, the employee, has indicated that she had a son, she has a daughter, mother, and the father. Now, in the writ petition, they have misled and suppressed the fact. It is stated that son has expired in the year 2009. That record also has been gone down to the ECL authorities also. The confusion arose from there. Now, the only thing is that, your Lordship, in 2023, the son came up with a representation saying that I am alive. Now, we came to know from the police verification that Berkey Majan is the stepmother of the son.
Who is this lady?
Lady is the daughter of the Berkey Majan of the employee. Now, the position is like this. The Provident Fund has been disbursed. Gratuity, we have intended to give the requisite amount to the controlling authority. Because of this rivalry claims they returned. And apart from that, rest of the amount, Your Lordship, that is the reason, Your Lordship, I'm praying to file a report, what steps we have taken, what is the record, who are the nominations.
Actually, my lord, the
There is-
person is saying,
Material
no,
fact
my lord,
from the
actually,
petitioner.
The petitioner
nomination is not the one of
claims to be one of the heirs and legal representatives of a deceased employee of the Eastern Coalfields Limited. Stop. She seeks terminal benefits of the deceased. Stop. Paragraph. Learned advocate representing Eastern Coalfields Limited seeks time to file a report. Stop. It has been submitted that there are rival claims. Stop. There has been suppression of material fact. Stop. Paragraph. Let a report be prepared and circulated within a period of 4 weeks. Reply, if exception, if any, within a fortnight thereafter. Liberty to mention the matter immediately on conclusion of the aforesaid time period. What is the supplementary?
Petitioner stated that he is the only legal heir.
That case saying all.
When I have got information, my lord, then my lord stating the facts. I am the only.
My lord, leave to file the exception also if required.
A supplement is kept.
Much of it.
Item number 221.
So I oppose for the respondent, Union of India, respondent number 1.
Other side is not here today.
They don't seem to be here much.
In that case, not today.
221.
20 lordship appear for the BCCL lordship. Your lordship kindly see the last order dated 25th September lordship. The landed coordinate bench lordship directed us to serve the copy of the writ petition lordship. Till date lordship no copy has been served out, neither the BCL directly or the landed advocate who is the embedded advocate in this case lordship. But today is the
Monday, I'll take it up.
lordship. Great lordship.
I'm praying for the petitioner. Same. Well,
Not today.
I'll seek one indulgence, my lord. That we have obtained no objection in this matter, my lord. The signature has been done here instead of here. Department is not kindly leave may be granted.
All right, leave granted to the learned advocate on record of the petitioner to file the no objection wakalatnama in the department in course of the day. The matter will retain its position in the list, or let it be listed in the daily list. Since order is passed, daily list on Tuesday, I'll keep it. Tuesday.
Lord, I beg to appear for the petitioner, my lord.
Who is the other side?
Lord, Mr. Rojo. My lord.
Don't know. And who
Lord,
is the
led by Mr.
what is the connecting application for?
It is for model lordship. Extension.
Has it expired?
Yes, lordship, it was expired. I
Then
pray.
bring your other side.
Mr. Rajat Datta is appearing for the High Court administration, lordship. I will inform them, lordship.
Not today.
Item number.
I am for the state respondents.
Lord, I am for the petition.
And no other respondent apart from the state?
My lord.
State and my lord, the petitioners.
My lord.
My lord, this is a case my lord, where the petitioners are engaged as special police officer in respect of a Maoist area of the district of Purulia. As per the meeting of the central government and the state government, and the order has been given by the DM, and thereafter, my lord, the superintendent of police, SP of the said authority has been taken place. Now, my lord, the petitioners were appointed on, my lord, in the year of 2012. After serving 10 years, suddenly the SP of the said area stated that all the SPOs, there is no need, and, my lord, all the SPOs are not working. And you should again inform after 2 to 4 days. Thereafter, what happens, my lord? After that, 19 out of 30 has been joined, 11 has not been permitted. In this regard, my lord, several representation has been made, but we are not giving any appointment. My lord, we are thereafter the petitioner came before this honorable court. In the first instance, my lord, this coordinate bench of this honorable court directed the state to file report. But probably that is with your lordship. In the report, they said that my lord, our behavior, we are not attending the such and such, like that one. Wherein, in the report, when the court asked them to whom you are, since that area is a Maoist area, they have already appointed other. And, my lord, in this regard, there is a judgment of the Supreme Court that if you require the regular casual worker, you cannot deny the claim of the casual worker who are being appointed without any reason. Their reason are not, my lord, sufficient. That's why, my lord, this matter has been came. But in the exception, I have taken the point, the person concerned who are appointed, amongst them, some of them are, my lord, already, my lord, in the police record, their names in respect of, my lord, the criminal cases. They have been appointed, but we are not considering due to the reason. My lord, last occasion, this honorable court, when heard the matter, this honorable court directed me to submit probably a judgment regarding whether the we can be the last order in this regard passed by the Supreme Court, the Jargo versus Union Revenue, whether that can be applied in this case or not. That is the, my lord, contentions the last one. Thereafter, matter was not heard. But I am coming to your lordship, the one by one the documents of mine. Your lordship, I'll kindly come to the first page 15, annexure P1. That is the appointment of the petitioners. 15A is the true copy, and 16 and 16A is the true copy. Where from your lordships got our names. All the petitioners are there. Now, my lord, we have attached our identity card. Your lordship, kindly come to our representation where we have written. আমরা পুরুলিয়া জেলার অন্তর্গত বাঘমুন্ডি থানা সুইসাফারির অধীনে একটি মাওবাদী উপদ্রব এলাকাতে ইংরাজি 1 আগস্ট 2012 সাল থেকে এসপিও পদে নিযুক্ত হয়ে আমাদের দায়িত্বগুলো যথাযথ পালন করে এসেছি। কেউ নাশকতা সৃষ্টি করতে না পারে, কিন্তু ইংরাজি 1/8/2023 তারিখে পরিকল্পিতভাবে আমাদেরকে অনির্দিষ্টকালের জন্য বসানো হয়। অতঃপর দীর্ঘ 5 মাস পর বাঘমুন্ডি থানাতে ডেকে আমাদের কাছ থেকে সমস্ত প্রয়োজনীয় কাগজপত্র নেওয়া হয় এবং উক্ত সময় আমাদের বলা হয় যে 2-4 দিনের মধ্যে পুনরায় তোমাদেরকে এসপিও পদে নিযুক্ত করা হবে। কিন্তু অত্যন্ত দুঃখ এবং কষ্টের বিষয় যে আমাদের 30 জনের মধ্যে 19 জনকে উক্ত কাজে নিযুক্ত করা হয়, অবশিষ্ট 11 জনকে এখনো পর্যন্ত নিযুক্ত করা হয়নি। এমত অবস্থায় আমাদের পরিবার আর্থিক সংকটে ভুগছে, অতি কষ্টে দিন অতিবাহিত করছে। অতএব মহাশয়ের কাছে আমাদের বিনম্র নিবেদন এই যে যাতে অতি সত্বর আমাদের অবশিষ্ট 11 জনকে পুনরায় উক্ত কাজে নিযুক্ত করে তার ব্যবস্থা গ্রহণ করাতে মর্জিত। My lord, this letter has been sent to authority.
Show me Jago.
Jargot, এটা Jargot judgment টা But probably one copy has been given to the court. Oh, I have one copy, my lord.
1 minute, দাঁড়ান দেখে নি। No, Jago is not here. Not here.
Yes, I have given my lord. Now, my lord. Your lordship kindly see. I have another.
এটা ফেরত দিন তো, 2টো কপি দিয়েছে।
না 2500 আছে।
Not ready?
Yes, my lord.
Not ready? Which portion of Jago are you relying on?
Paragraph 25, 21 onwards. Your lordship kindly paragraph 20 onwards.
All right.
It is well established that the decision in immediate does not intend to penalize employees who have rendered long years of service fulfilling ongoing and necessary functions of the state or its instrumentals. The said judgment sought to prevent backdoor entries and illegal appointments that circumvent constitutional requirements. However, where appointments were not illegal but possibly irregular, and where the employees had served continuously against the backdrop of sanctioned functions for a considerable period, the need for a fair and human resolution becomes paramount. Prolonged, continuous, and unblemished service performing tasks inherently required on a regular basis can, over the time, transform what was initially ad hoc temporary into a scenario demanding fair regularization. In a recent judgment of this court in Vinod Kumar and others, Union of India and others, it was held that the procedural formalities cannot be used to deny the regularization of service to an employee whose appointment was termed temporary but has performed the same duties as performed by the regular employees over a considerable period in the capacity of the regular employee. The relevant paras of this judgment have been produced. The application of the judgment in Nomadevi by the High Court does not squarely
Read this portion.
Now, my lord, next paragraph. The High Court placed undue emphasis on the initial level of the appellant's engagements and the outsourcing decision taken after their dismissal. Courts must look beyond the surface levels and consider the realities of employment, continuous, long-term service, indispensable duties, and absence of any malafide or illegalities in their appointment. In that light, refusing regularization simply because their original terms did not explicitly state so.
But
or
this is
because
not a case of regularization.
practically, my lord, what happens? We have been, my lord, ousted without any reason. Because, my lord, if it is the occasion of the state authority that there is no requirement of any other such type of employee, I can understand. But Out of 30, they have again engaged 19 and excluded 11. And again, they have engaged from outside. Without giving any reason why these petitioners are not appointed. Only vague, because as per the police regulation, section 17 of the Police Regulation Act, even for a misconduct, we have to give in a show cause notice. And in our this 11 years of service, no show cause notice, no penalty has been issued against me. So, their allegations totally baseless. Only to remove us for some unknown reason, we have been due. And they are engaging other peoples from the outsider. And also, after getting the report from the state authority, we are taking this point that some persons who are engaged in their names, criminal case are still pending regarding theft like that, whole theft like that. And they are guarding the railway track. They have been appointed for railway track. আমাদের এটা State Bank. Also, since regarding question of Article 14 here, I am producing another judgment, 1991 one Supreme Court cases, page 212. After your lordship go through this judgment, this is a the last judgment passed by the Supreme Court so far. I go through.
LWE means left wing extremists or what?
LWE, not sure.
Yes, man.
LWE?
Lordship, kindly refer the portion.
Everywhere it's mentioned LWE.
Report
LWE affected state.
My lord, kindly.
Left-wing extremists.
Left-wing extremist.
What else do you want to submit?
Yes, my lord.
What else do you want to submit?
My lord, I also taken a point of Article 14 regarding, my lord, the disparity of the state action in respect of other 19 persons and between us, because out of 30 they are disengaged us. My lord, in this respect, I am producing another judgment of the Supreme Court, that is 1991 one Supreme Court cases, page 212. Your lordship kindly come to stateway. Para 24 at page 237. The state, may I read my? The state cannot be attributed the split personality of Dr. Jekyll and Mr. Hyde in the contractual field so as to impress on it all the characteristics of the state at the threshold while making a contract requiring it to fulfill the obligation of Article 14 of the Constitution, and thereafter permitting it to cast off its garb of state to adorn the new robe of a private body during the subsistence of the contract, enabling it to act arbitrarily, subject only to the contractual obligations and remedies flowing from it. It is really the nature of its personality as the state which is significant and must characterize all its action in whatever field, and not the nature of function, contractual or otherwise, which is decisive of the nature of scrutiny permitted for examining the validity of its act. The requirement of Article 14 being the duty to act fairly, justly, and reasonably, there is nothing which militates against the concept of requiring the state always to so act, even in contractual matters. There is a basic difference between the acts of the state, which must invariably be in the public interest, and those of a private individual engaged in similar activities, being primarily for personal gain, which may or may not promote public interest. Viewed in this manner, in which we find no conceptual difficulty or anarchism, we find no reason why the requirement of others should not extend even in the sphere of contractual matters for regularizing the conduct of the state activity. Now, my lord, your lordship, then come to
Please come.
Ajal sir, page 48 of that.
The petitioners were, the petitioners, comma, 7 in number, comma, were deployed as special police officers by the Deputy Superintendent of Police within bracket headquarters Purulia, in the year 2012. Stop. They were particularly required to guard the trains throughout the day and night, especially in the left-wing extremists affected areas. Stop. They have filed the instant writ petition in September 2024 with the allegation that they have been disengaged from service with effect from 1st August 2023. Stop. A representation was addressed to the officer in charge, Bagmundi Police Station, on 19th June 2024 with a request to permit them to join service. Stop. As there was no response from the end of the respondent authority, the instant writ petition has been filed. Stop. The petitioners pray for a direction upon the respondents to permit them to join their respective duties and to regularize them in service. Stop. Paragraph. It has been submitted that out of the total 36 special police officers, উপরে একটা SPO ব্র্যাকেটে দিয়ে দেবেন তো একদম ফার্স্টে
30 my lord.
আচ্ছা 30 SPOs were কি বললাম out of the total it has been submitted that 30 SPOs were appointed on the same day, but the respondent authority illegally and arbitrarily directed how many? 11.
All, first of all, my lord, all 30s have been my lord, directed to my lord. Thereafter, out of 30, again 19 have been reappointed and 11 has been
Only
left.
factually, my lord, only I indicate. On 28th of August 2023, prior to that, 36 SPOs have been appointed. Out of 36, 20 on the basis of a report have been demobilized.
But this is in 23. They are there since 12. I have seen 36 and that is the reason I said. But then right now it is only the total. That same day, stop করুন তারপর লিখুন all 30 of them were demobilized, but thereafter the authority illegally and arbitrarily permitted 11 of them to rejoin duty, but the rest have not been permitted to join.
My lord,
19.
Out of them, 19 have been illegally and 19 have been again rejoined, 11 have been left out.
আচ্ছা 19 join 11 বাদ আছে ঠিক আছে out of them 7 has come.
Yes, ma'am.
আচ্ছা but rest 11 of them were not permitted to join. Stop. Out of the 11 the instant writ petition has been filed by 7. Stop. It has been submitted that the reason for not permitting the petitioners to rejoin duty has never been disclosed. Stop. The state, cannot discriminate between two similarly circumstanced persons. Stop. If the authority permitted 19 SPOs to rejoin duty, comma, the authority ought to have permitted balance 11 to rejoin on the same date. Stop paragraph. The a point of discrimination has also been taken by the petitioners. Stop. In support of the submission that the state ought not to discriminate between two similarly circumstanced persons, comma, learned advocate for the petitioner relies on the judgment delivered by the Honorable Supreme Court in the matter of Kumari Srilekha Vidyarthi and others versus State of UP and others, reported in 1991, 1 SCC 212. Wherein the court held that the requirement of maintaining Article 14, not maintaining, complying with Article 14 should extend even in the sphere of contractual matters for regulating the conduct of the state. Stop. The requirement of Article 14 is the duty to act fairly, comma, justly and reasonably. As regards the issue of regularization, comma, learned advocate for the petitioner relies on the judgment delivered by the Honorable Supreme Court in the matter of Jaggo versus Union of India, reported in, একটু রিপোর্টিংটা দেখে নেবেন তো, এখানে কিন্তু রিপোর্টিংটা নেই, আপনাকে নিয়ে নিতে হবে। Wherein the court held that it is imperative for the government departments to lead by example in providing fair and stable employment. Stop. Engaging workers on temporary basis for extended periods, comma, especially when their roles are integral to the organization's functioning, comma, not only contravenes international labor standards, but also exposes the organization to legal challenges and undermines employee morale. Stop. By ensuring fair employment practices, comma, government institutions can reduce the burden of unnecessary litigation, comma, promote job security, and uphold the principles of justice and fairness that are meant to embody. Stop. Learned advocate representing the state respondents opposes the prayer of the petitioner. Stop. The report filed by the Superintendent of Police, Purulia, signed on 23rd of September 2024 is relied upon. Stop. On a perusal of the report, it appears that the special police officers were deployed to guard the railway tracks in the interest of passenger security on Kharagpur-Mednipur-Adra and Kharagpur-Tatanagar within bracket West Bengal portion bracket close rail route. The SPOs were getting their honorarium of rupees 3,000 per month from the security related expenditure scheme of the Ministry of Home Affairs. Stop. The SPOs were engaged among the active sources of the LWE police stations. Stop. They were to provide information about the activities of LWE throughout the rail route and keep the police informed about the local input in connection with subversive activities of the relevant area. Stop. Their deployment was purely contractual for a specific purpose to deal with the situation necessitated at the material point of time. Stop. A report was submitted by the Subdivisional Police Officer Jhalda, Purulia before the Superintendent of Police, Purulia against 36 number of SPOs deployed under the Bagmundi Police Station and Jaipur Police Station. Stop. The said SPOs were found to be indisciplined, reluctant, and irregular in their duties. Stop. They failed to collect and provide any information about LWE activities, which was their primary duty. Stop. They were reluctant to perform their assigned task and failed to collect relevant information in connection with LWE movement. Stop. Paragraph. The Subdivisional Police Officer, Jhalda, requested SP Purulia to demobilize them for their unsatisfactory performance / inactivity of duty and proposed to deploy new local youths having good reputation in the locality and good connection in the ground level for the same purpose. Stop. Relying on the aforesaid report of the SDPO, the Superintendent of Police disengaged 36 SPOs from the month of August 2023. Stop. After disengagement, the activities of the said SPOs were reviewed. Stop. On review, it was found that nearly 20 of them may be re-engaged upon caution. Stop. Accordingly, 20 SPOs were cautioned to perform their duty without any negligent attitude. Stop. The said 20 SPOs were specifically briefed about their duties, namely Number one, to guard the railway track, set out this 1, 2, 3, 4, 4. Stop. Identity cards were issued from the concerned police stations to the SPOs to avoid harassment from the railways or other authority during their duty period on the rail route. Stop. The rest of the demobilized SPOs were found to be extremely casual and they lacked the required potential to collect information for prevention of subversive activities along the railway track. Stop. Their reluctant attitude, negligent conduct, irregular presence at the assigned duty do not suit the purpose for which they have been deployed. Stop. Paragraph. It has been submitted that the petitioners fall within the 20 SPOs who have been demobilized because of unsatisfactory performance. Stop. Paragraph. Prayer has been made to dismiss the writ petition. It has also been submitted that the petitioners have not made out any case for regularization of their service. Stop. It has been denied that there has been violation of Article 14, violation of the principle enshrined in Article 14 of the Constitution. Therefore, a prayer has been made to dismiss. I have heard the submissions made on behalf of both the parties and have perused the materials placed before this court. Stop. Paragraph. It appears that the petitioners were deployed as SPOs. Stop. Not stop. For a particular purpose. Stop. The SPOs were primarily required to collect information and inputs about the terrorist activities in the railway tracks. Stop. The authority demobilized the petitioners as they were unable to provide the relevant inputs and they were found to be casual and irregular in their duties. Stop. There is no reason to engage a person who does not satisfy and or fulfill the purpose for which they have been engaged. Stop. The SPO's role is very vital for maintaining public safety and also for maintaining the safety of the railway tracks. Stop. The petitioners have failed to deliver the work that they were supposed to perform. Stop. Paragraph. Now, even after demobilization of their service, the authority reviewed the performance of the demobilized SPOs and have reappointed several of them who, according to the authority, were in a position to serve the purpose for which they were engaged. Stop. The even on review of the performance of the petitioners, the respondents were not satisfied to re-engage them. Stop paragraph. The not the Jaggo within bracket supra deals with regularization of temporary or contractual employees. Stop. The petitioner has miserably failed to make out a case for regularization. Stop. The petitioner's performance have not been found to be satisfactory, for which they were demobilized from their service. Stop. This is not a case where the petitioners seek regularization. Stop paragraph. In Sri Lanka Vidyarthi within bracket supra, comma, the court emphasized the role of the state in following the principles of Article 14 of the Constitution. Stop. On a perusal of the facts and circumstances of the instant case, it does not appear that there has been violation of Article 14 in any manner whatsoever. Stop. It is only because of the unsatisfactory performance of the petitioners and their indisciplined and casual attitude towards their work that led to their demobilization. Stop. The same cannot be said to be in violation of Article 14 of the Constitution. Stop paragraph. In view of the discussions made herein above, comma, the court is unable to accept the prayer of the petitioners to either permit them to rejoin or direct the authority to regularize them in their service. Stop. If the court entertains the prayer of the petitioners, comma, then the authority will have to depend upon SPOs who are unable to deliver their work, and the very purpose of their engagement will be rendered nugatory. Stop. Next. The court is not inclined to exercise jurisdiction in the matter. The writ petition fails and is hereby dismissed. Next.
Lordship, in this matter, I am for petitioners. There are three matters, 225, 226 connected matters. These matters are being filed seeking a direction against the respondent number 1 to 3 to comply the report submitted by respondent number 4. In this manner, pleadings are completed. Now, if my learned friend is
Lordship,
there,
if I may humbly submit before my learned senior friend starts submitting, Lordship.
You are representing?
Lordship, I'm representing the Union of India, Lordship, in all the three matters. Now, Lordship, in compliance to the last direction passed by the Honorable Justice Aniruddha Roy, Lordship, may I just humbly file the affidavit in opposition, Lordship, in 3 writ petitions, which we have already served upon them, Lordship.
Has the reply been filed also?
Lordship, only in one matter, Lordship, item number 227, we have received the reply, Lordship.
Item number 227, my lord, I am for the petitioner. Mr. Shukriya Chakraborty is appearing in this matter, my lord. His mother expired today morning. Kindly take it out.
Lordship, initially they filed a report to which exception affidavit we have filed. Now they are seeing that they have filed an
affidavit in opposition has been filed.
That is there.
Are all the matters required to be heard together, or 225 and 226?
Lordship, in fact, only name and case numbers are different. Issue is same in this all matters.
Then one of the counsel has suffered a bereavement, so I will adjourn the matter for the day.
No problem, Lordship. May I request one thing, since I am out of station, if Lordship may have fixed any definite date.
Lordship,
give it-
I have a similar prayer, Lordship. I'm led by the learned ASD, Additional Solicitor General, Mr. Ashok Kumar Chakraborty, in this matter. If your Lordship may kindly fix a date and time, Lordship, for 3 matters in the coming week.
Correct.
Lordship, I'll be obliged.
Please come. Affidavit in opposition on behalf of the respondents. Check out the numbers in which these oppositions have been filed. In court today be taken on record. Stop. Did you file a report earlier?
Lordship, there was
Yes,
one
Lordship,
report
they have
earlier.
filed
Lordship,
report.
This is the affidavit in opposition.
Do you intend to file a reply to the opposition?
Lordship, I will see it because up to the report, we have already filed exception affidavit. Now it is new thing,
Yes.
affidavit opposition.
Would
If
you like-
required, we will file within a week, if required.
Acha, it will be open for the petitioners to file exception, not exception, it will be affidavit in reply to the same.
Correct.
Within a fortnight. Stop. Release the matter. What is the matter about?
Matter is, Lordship, in fact, indirectly for regularization and directly for
Regularization.
indirectly, Lordship, and directly for executing the report submitted by Deputy Chief Labour Commissioner. Deputy Chief Labour Commissioner has conducted inquiry under the direction of your Lordships, then submitted a report. They are not executing, they are not complying the report. That is why we are before your Lordship in this matter. Report is already on record.
Lordship, at the face of it, the maintainability issues were raised, Lordship, on the last occasion.
Release the matter for further consideration on 24th of April 2026.
Lordship, may a time be fixed, Lordship?
Yes.
Kindly, a time.
Lordship, may fix time so that I can easily.
Lordship, we humbly praying, Lordship.
10:30 in the morning.
10:30.
Lordship.
Grateful, Lordship.
Till 4:30 in the evening.
Grateful, Lordship. Please, your Lordship, grateful.
Lordship, I appear for the respondent. Your Lordship, there was a direction upon me to file my report, which I failed to do, Your Lordship. I'm seeking 1 week's time. It's my fault, Your Lordship. There's been a.
The direction was passed in December.
Yes, Your Lordship. That too of 24.
Then
Lordship, it was completely my fault. It was.
why will this leverage be shown to you?
Lordship, my report is now. I have sent it for approval. Within a week, I'll file it, Your Lordship.
On the prayer of the learned advocate representing the Airports Authority of India, time to file the report. In terms of the order dated 23rd of December 2024, stands extended peremptorily till 6th of April.
Lordship, within 1 week, I'll file it by Friday.
Released 24th of April.
Obliged, Lordship.
But then it will be open for the petitioner to file an exception to the
May
report.
not.
I do not know.
Not if they are filing by 6th of April, not we can by.
Yes, that is the reason. Next.
29 for the petition.
Other side?
Other side is
Not
to have hearing.
Not today. Not today.
Also, I put the petition on this. Earlier, honorable.
Your other side, please.
Mr. Amit Kumar Sen, HON'BLE Kumar Sen appeared on
Where
behalf.
is he?
There is affidavit of service. Earlier occasion direction was passed by
Not
one
today.
coordinator bench.
Next. You have three
Malad 233, Malad, in this matter, Mr. Sopanand is appearing for the respondent, Malad, Union of India, Malad.
The petitioner, I'm led by Ms. Bhuma Sen. I'm praying for not today. She's out of station.
Not today.
Grateful.
Get clear.
Lordship, I'm appearing on behalf of LICI, Lordship. May I just crave leave, Lordship, to file the affidavit in opposition in this matter?
If the petitioner is not here, then I'll not take it. I'll make it not today.
Grateful.
Madam, for the petition. Lordship, only one more thing that another analogous matter is pending before this honorable court, and that should be heard together, Your Lordship. So I'm giving, if I give the
Give the number. Let this writ petition appear along with WPA such and such. Stop. Let notice be served upon the respondents. Stop. Released on 13th of April.
I'm for the respondent, my lord.
Petitioner is not here. You are panting. Take rest. Not today.
Two 38, may I please, Lordship, I am for the petition. My lord, can it be taken up on 9th?
9th?
9th. My lord, 9th is your Lordship's contempt day, my lord, 10th, my lord.
Friday?
Friday.
All right. But then these motions are taken up in the morning. I can take it up on 9th also.
9th. Then
9th.
9th.
Listed niche 9th लिखे देवन.
Yeah.
Two 39 also 9th.
39, my lord.
9th.
9th.
Two 39 হয়ে গেল তো. Not today.
On
41,
instruction I am submitting in this matter, I am for the petition. On instruction I am submitting. This fellow has got the job in this selection process, my lord.
Very well.
Although the communication has not been made yet.
Very well. 241.
My lord.
Shudip Das.
Shudip Das, yes.
All right. A learned advocate for the petitioner submits upon instruction that the petitioner has already appointed in CAPF. Stop. The petitioner is not inclined to proceed with the writ petition any further. Stop. In view of such submission, the writ petition stands dismissed as not pressed.
Much obliged.
242, 9th. 243, 9th. Don't call any other matter.
244. I am for the petitioner.
All right, please
Possibly
call.
other side is.
Is there or not?
Lordship, I appeal for the state respondent.
All right, then call 244.
My lord.
4.
244.
243, 9th আছে কিন্তু. এটা 244. Yes.
Lord, my junior, Srijata, before my lord, she's filing the my lord report.
All right.
Exception to the report.
All right.
Now, my lord, petitioner is a work facilitator appointed in the year of 2009. Thereafter, my lord, government time to time issued various annexures, various memos, so that like petitioner others can be
Lordship, I
benefited.
filing my report as previous direction.
Yes, then
Then, my lord, last occasion, this is third type of litigation. Now, they considered, but they handed over district magistrate to other officer. He did nothing. Now, your lordship, kindly see last annexure. I am praying said order. Justice Mantha Miller passed similarly situated person last annexure. Page 58. My lord, got it? Second para, my lord. It appears from the record that the writ petitioner has been working satisfactorily as facilitator. Actually, this is block facilitator under ICDSS, under the Chopra ICDSS project, under the CDPO Chopra. Uttar Dinajpur, my case is Dakhin Dinajpur. She claimed that her remuneration remained unchanged from 2009 till date. My case is also 2009. I was appointed, not a single farthing they have enhanced.
Are you getting rupees 9,000?
Yes.
All right.
9,010.
9,010. Are you aware as to what happened pursuant to the order passed in the matter of Choitali Paul?
Yes.
What happened? Did they increase the
So far, my
remuneration?
limited knowledge goes beyond the enhance.
They have?
Yes.
What is the state stand?
Lordship, my instruction is from the kind Lordship consider the last nature of my report, Lordship, that is also annexed with this petition, that he is not redeployed, Lordship. For those who redeployed, he will be continue for the more than 10 years. Yes,
have you demobilized the petitioner from service, or he is still there?
He is not there, perhaps, Lordship.
He has gone from service.
Lordship.
He is not in
No.
service.
No, see them working.
From it appears from the
See them
order
working.
passed by the last annexure kind Lordship.
When did you get your last remuneration?
My lord?
When did the petitioner get his last remuneration?
Third, fourth.
The said memorandum was issued to provide certain benefits on the pay and other of those employees contracted
this month.
who were redeployed.
This month.
This month you got your honorarium?
Yes. I have to take further instruction, Lordship. Sorry, Lordship.
What do you mean to say he has been?
Then I have to take instruction, my lord.
What instruction? Your report is here. What does your report say? That he has been demobilized?
No.
Then?
My report said he is not entitled to get the further benefits because he is not redeployed.
What do you mean to say redeployed? He is still in service. Question of redeployment does not come. How do you distinguish from the order that has been passed in June 2024 in the matter of Choitali Paul?
I have one submission.
Absolutely same.
They have made certain referred the certain notification memo numbers, Lordship, which is not available here to me, Lordship.
What do you mean to say? 9008 has been made applicable in respect of the CDPOs.
No, I'm
facilitators who are working in the CDPO.
Which was deferred in order, Lordship. Can you consider last annexure, Lordship?
Page.
Last annexure of my report.
Page.
At 17, Lordship.
17, yes. What does it say?
The portion of the order, Lordship, the petitioner cited the memorandum of such and such and demanded that his pay and other benefits shall be made according to provision of the said memorandum. The said memorandum was issued to provide certain
Where are you
benefits.
reading? Where are you reading?
At page 17, Lordship,
Page 17?
from my report.
Page 17, which portion order?
Last portion.
All right. Shall be made according to the
provide certain benefits on the pay and other emoluments of those employees, contract workers who were redeployed in compliance with the Memorandum of Finance Department white number such and such. Therefore, it is clear that the Finance Department memorandum number such as is applicable only for such employees who were redeployed to other entitled organizations in terms of the provision contained in the memorandum.
2014 of the Finance Department. Hence, for the reason stated above, the contention of the petitioner, he shall be made eligible for such and pay other as per the Finance Department dated such and such. Though the petitioner particular demand is rejected, it is hereby ordered that the DPO-ICDS will examine whether the remuneration received by the petitioner and such workers is in order to per the guidelines of the Finance Department with respect to the wages.
This is the order under challenge, isn't it? The question is whether the petitioner would be entitled to the same relief as granted in the case of Choitali Paul. The petitioner relies upon 2011 memo 9008 and this 2019 memo is only in furtherance of that. Have you annexed all those memos?
No, that is not.
Why?
That is not annexed.
Not annexed. You are defending your memo without annexing it. Is it annexed in the writ petition? Has the petitioner annexed that? What type of a writ is this if you have not annexed it? You've annexed the order of one Sanjeev Kumar Laha, where this person possibly was demobilized. Here the petitioner is in service and he is getting his remuneration. Why will
This month also.
Choitali Pal not be available to him?
Can you grant me 1 week time?
I may record my submission. This month, first week, I receive my remuneration. I'm still continuing since 2009.
Of the District Project Officer within bracket ICDS, Dakshin Dinajpur. And the exception there too by the petitioner. Filed in court today, be retained with the records. Stop. The petitioner claims similar relief as granted by this court. Video order dated 20th June 2024, page 58. In WPA 2337 of 2023, Choitali Paul versus the state of West Bengal and others.
Right.
Stop. Learned advocate for the petitioner submits upon instruction that the petitioner is still in service and he is getting the remuneration of rupees 9,010 only per month. Not remuneration, remuneration.
9,110.
Acha, 9,110 per month. Stop. In Choitali Paul within bracket Supra, the court directed the District Magistrate Uttar Dinajpur to revisit the to revise the writ petitioner's remuneration in terms of the Finance Department memo number 9008 hyphen.
Lordship, if he is untitled, Lordship, continuing the service, Lordship, according to
dated 16 September 2011. Which stood revised from time to time and lastly in the year 2024.
Yes. Let's put my
just a minute.
Learned advocate
He's
representing the respondents relies on the report and submits that the benefit of the circular can be provided only if the petitioner is redeployed in service. Yes, what else?
My he's covered under the Choitali Paul, Lordship, because he's continuing this.
Yes.
He's continuing the service.
So I set aside this order?
Yes.
Achha. redeployed in service. ঠিক আছে? Paragraph. Upon hearing the parties, it appears that the petitioner is continuing his service on and from the date of his first engagement in the year
2009. 3rd June 2009.
on and from 3rd June 2009. Stop. He, as the petitioner was never out of employment, comma, the question of redeployment does not arise.
I'm grateful to him.
The court, paragraph, in the matter of Choitali Paul within bracket Supra, passed specific order directing enhancement of wages in terms of wages, comma, salary and remuneration in terms of the Finance Department memo number 9008-F within bracket P dated 16 September 2011. Stop. No reason or ground has been put forth in the report differing from the facts of the case of Choitali Pal. Stop. There is no reason as to why the decision passed in the matter of Choitali Pal will not cover the petitioner in the instant case.
Great.
Stop. Next. In the matter of Choitali Pal, the incumbent was within the jury, was serving as facilitator under the Chopra ICDS project, Uttar Dinajpur, since 2009. Stop. In the instant case, the petitioner is serving as the facilitator under where?
Dokhin Dinajpur.
Dokhin Dinajpur. Stop. The court in Choitali Pal directed the DM to revise the remuneration. Stop. Similar order is passed herein. Stop. The district magistrate Dokhin Dinajpur is directed to revise the writ petitioner's remuneration in terms of the aforesaid department memo as revised from time to time, lastly in the year 2024. Stop. All arrears of payment of the petitioner shall be released within a period of 3 months from the date of communication of this order.
Lordship, can you extend some date because some election process?
3 months. Here it was 45 days. I have given you double the time.
At that time, the election was not in knocking the door. At that point of time, the election was not knocking the door. Your Lordship, this time.
Maybe that is the reason I have doubled the time. ঠিক আছে? The writ petition stands disposed of.
I'm grateful to your lordship.
Have you too?
Even 47, can it be taken up on 9th?
All right, 45,
5
56. Is
46.
anybody there?
No, my lord, no.
245, is anybody there for the respondent? 9th.
And 247, my lord.
247, anybody for the respondent? 9th.
Much obliged.
All right. Listed niche Which matter? Parag, see, last occasion also nobody was there. Even prior there to this is the third week. কোটে ব্যস্ত? কেউ আছে একটা অর্ডার নিন তো। ফাইল দিতে হবে না, but then one order will please. Yes, this is the third occasion that the private respondent is not appearing and there is no records. The last দিনে একটা order record করতে হবে. Hearing of the writ petition is adjourned due to non-appearance of the private respondent. The নামটা লিখে দেবেন because he is an applicant in one of the matters. Who is the private, what is the name of the private respondent? Private respondent's name.
Private respondent is Mamta Agarwal.
Mamta Agarwal, তাহলে ওটাই লিখে দেবেন।
Lordship,
Because
it's my
he is
mistake.
an-
It is Shafiq Ahmad, Lordship, the private respondent. It is Shafiq Ahmad.
He is the applicant in one of the matters.
Yes,
it-
he is the applicant and he is the private respondent also.
Shafiq.
Shafiq.
Ahmed.
একটু চেক করে নেবেন প্লিজ।
Shafiq Ahmed.
ঠিক আছে, কে আছে সেটা একটু দেখে নেবেন। ঠিক আছে, any other matter? No. ঠিক আছে, চলো। আচ্ছা, um, 20th and
Your Lordship,
27th, same order will go
the
down.
one's indulgence, Lordship, coming Friday, probably it's a holiday. Good Friday. So, my lord, can it be on Thursday?
No.
No, on Friday.
Wait.
itself. No. Okay.
And it will go to the 10th of April.